Hello again. Thank you for joining us this afternoon. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. We have Chris Gelwicks with us today to talk all about collections. Hopefully, you don't have collection issues, but I'm sure at some point you will. Um, nature of the beast when dealing with all of the challenges in community associations. As a reminder, we do record these sessions and we do post them on our camsmgt.com website under the board member resources page. If you haven't been to our new and improved website, please take a look. A lot of effort went into making that happen. It's got a great new look and we're really excited about all the information that can be found on the website. If you do have questions, we will facilitate those questions and do hope that you ask many. So I will read those questions and let Chris answer them at the end of the session. And if there's a good question that comes along halfway through, I may stop Chris and ask that question just for relevancy. So with that, Chris, I will turn it over to you, get us started, and tell us about your new firm that you are with, since that is a change since you last presented for us.
Yes, that's true. Hi, everybody. Chris Gelwicks here with Law Firm Carolinas in Charlotte. Yes, in February of this year, I changed firms. If you've seen me previous to this, I was with the McIntosh Law Firm, which was in Davidson, and I moved to Law Firm Carolinas. I think my first day was February 4th. It's been a good change, a lot of work, but it was a good refresher on some collection policies actually, because the way I did things at Macintosh is a little bit different than here. Nothing right or wrong about it, just different. So this is a good topic. And For everybody who's listening, I have worked in both North and South Carolina law here. For those of you who are familiar, the processes for each state are very different. You'll see, if you have not seen that before, you will here. It's going to be a high level view. We're going to go fast. So certainly send in your questions and we'll get moving. What we're going to cover, what your governing documents and state law require to allow you to proceed to collection, what courts will expect when pursuing unpaid assessments. I know that firsthand. Before I came to this firm, I was going to every hearing. I don't do that so much now over the last few months, but still occasionally. I will tell you, each clerk of court and each judge is a little bit different. We'll talk about that. Going to see weaved in amongst all this is some of the challenges that we face in collections, the potential challenges to how the laws could potentially change. North Carolina has some pending legislation that will change, if it passes, dramatically some of the things that we deal with. We hope to cover all that. We'll move fast. I started this though with sort of just a very quick, basic understanding of what the law expects of you as a board member. If you've never heard this term, the business judgment rule, the business judgment rule is something that applies to all board members. You are required as a board member to exercise your fiduciary duty. And what that really means is to act in the best interest of the association, to use your best business judgment when making a decision. That includes making a decision on collection policies and proceeding to collection activity, whether lien foreclosure. Addition to that is the reasonably prudent person rule. It's an offshoot of the business judgment rule. You're supposed to basically act as someone reasonably would in your situation. And then uniformity. As boards, and look, let me just preface this. I used to sit on my board. And when things would come in, it is sometimes very difficult to act without taking something personally or without having a personal stake in it. Um, Acting uniformly in actions and enforcement and in collections is going to ensure that you have as few headaches as possible. Um, Litigation results when boards differ from policy, when boards do not follow procedures that are set forth in their documents for whatever reason. And we'll talk about that as we get into this a little more. Let me talk about the differences between North Carolina and South Carolina. And I hope I don't offend anybody, but I got the North Carolina blue and the South Carolina red going there. So, um, first of all, everybody, I hope, understands that you all are subject to your declaration of covenants or your master deed if you're in South Carolina in a condominium. And in those documents, every one of them, if you are a planned community, will have a section about assessments, the ability to assess and the ability to collect. In North Carolina, the collections, the process itself is statutorily driven for the most part. The code sections I cite there, 47F and 47C 3116, uh, and I actually put a different code section there, 45-21.16. I'll talk about that briefly, but enables a power of sale foreclosure, meaning in North Carolina, if you are collecting the current law is if you are collecting assessments or fines and assessments together, you are entitled to proceed through the foreclosure process through what's called the power of sale, and that is an abbreviated process, meaning there's not a lawsuit necessarily. It kind of is. It's court of what they call a hybrid or quasi-judicial proceeding. The foreclosure itself is started with what's called a notice of hearing, which is filed.
Hey, Chris,
Yes, sir.
your sound got really quiet. So maybe just when you move back and seat, but
Is it better now?
still a little quiet. But keep talking. We'll see.
Okay. I don't think I have not adjusted volume.
That's
So,
better. That's
okay.
better.
All right. So I'll recap real quick. So the statute in North Carolina, if you are collecting assessments or fines with assessments, you proceed through what's called a notice of hearing power of sale process. It's an abbreviated process. You can conceivably start with your collection process on January 1 and be finished if nothing happens within 120 to 150 days. In theory, that never happens, but in theory, it's possible. There are specific statute requirements that must be met in order for you to recover. We're going to talk about those. And notably, and one of the things that I always get asked is, how much do I have to prove the exact amount due? In North Carolina, there is no requirement that I have proved to a clerk of court that the exact amount is $1,562.18, for example. That's just a number off the top of my head. I need to prove that a delinquency exists. Now, reality is this, when I go into a hearing, the clerk wants to see the ledgers and all the amounts due. So we produce that. Um, if it's fines only, if you have levied a fine for somebody in violation and those fines have accrued and not been paid, but they are current on their assessments. The procedure right now is entirely different in North Carolina. It's akin to South Carolina, and I'll go over that when I go over to South Carolina. Um, in addition, your declaration of covenants may provide a specific collection process that you must follow, meaning, for example, additional correspondence being sent before a collection process can proceed, or a specific amount must be due before you may proceed, something like that. If that is in your documents, you must follow it. It has to be that you must follow it. If you don't, and we proceed, if we do get a foreclosure order, that could be challenged. One thing in North Carolina via statute, attorney's fees incurred in recovering in a collection process, recovering the amounts due, are all recoverable. Meaning, if you have to pay a homeowner's an attorney $5,000 to recover the funds, 47F 3116 clearly says that all those fees are recoverable. That's as of now. We'll talk about pending legislation down here a little bit in a little bit. That could change. South Carolina, there's no applicable statute that governs this. Thus, everything is entirely document driven. What that means is the power to lien and foreclose in South Carolina must be in your documents or you can't do it. It is a full lawsuit, meaning we are drafting a complaint. We are serving the defendant with a sheriff or certified mail, personal service. That is the same thing as what we must do in North Carolina when we are collecting only fines. It's a full lawsuit, filing a complaint, sending it to the sheriff or via certified mail for service. In South Carolina, the court will make a specific finding as to the amount due. So we must prove an amount due. And I will note this, as I indicated at the beginning, both North and South Carolina are different. I will tell you that county to county are different. There's a county in South Carolina right now that will not allow a foreclosure for homeowners association assessments if the amount due is less than $10,000. I just found that out Monday in a case. So that is not statutory driven. That is a judge's discretion. The judge granted us a money judgment in that case, but would not warrant the foreclosure because the debt was less than 10,000. So something to keep in mind that even if we cross all our T's, dot all I's, and present all the documents necessary, there is still a possibility a judge may decide that something that may not be in according to law, but in their discretion, they may not allow us to foreclose. That is generally not the case. Generally, we get what we want, what we're desiring to get, but you need to understand that the guys in the black robes, they run the show. Fines in South Carolina are treated just like assessments as long as the documents say they're treated like assessments. Additionally, in South Carolina, unlike in North Carolina where the statute says every penny of the attorney's fee is recoverable, in South Carolina, it is what's called reasonable attorney's fees. Reasonable attorney's fees is whatever the judge deems reasonable for the case that was brought before him or her. That may mean that if you pay an attorney $3,000 to foreclose in South Carolina, the judge may not award all of it. Now, my experience has been that the judge awards all of it. But there is discretion there that you all need to be aware of. The South Carolina process from start to finish can take anywhere from 6 months to 2 years, depending upon whether the case is contested. So that is a brief overview of some distinctions. I'm going to get in a little bit into the general process now, and where there is a difference in the process for either state, I will highlight that. So here's what happens when it comes to our office. When you as a homeowner association board decide that someone needs to go to collection because they've not paid their assessments, you have sent whatever documents are required to be sent by your declaration, a warning letter perhaps, if it's required to be sent. What is the first step in the process? In North Carolina, it is required that you send, and this is usually done by your management company, a letter that says after 15 days from the date of this letter, we are going to send your file to an attorney, and that attorney will begin the lien foreclosure process. That 15-day letter must have an amount due to that date and good for 15 days. That letter must also contain that in the event that you do not pay within the 15 days, when the matter is sent to an attorney, the attorney's fees will then accrue and the owner will be responsible for their payment. And again, I indicated that this letter is only required in North Carolina. I have found that for expediency and just for the uniformity of process, most everybody in South Carolina also sends these letters. So if this letter is not sent, the attorney's fees incurred in collection process are not recoverable. So it is vitally important that that 15-day letter be sent. Where do we send it? We send it through the statute requires that we send it to the property owner at all addresses that we know where the property owner exists or has on record, whatever they may be. It may be 5, it may be 2, maybe 1. And to any address listed on the tax records in the county in which the property is located. That may mean multiple letters. That letter does not need to be sent certified mail, not at this time. But it does need to go everywhere. If we get a file in and the letter does not go to all of the required locations, and we check that here, we will come back to the management company or to the association and say, you need to send the letter to this place as well and give them the information. That will delay us proceeding, but nevertheless, if that letter is not sent to all the places, we could have a problem down the road. So that starts the process. When we get the file in here after the 15-day letter, we take that demand letter, that 15-day letter, and we draft one here. We do that because the Federal Fair Debt Collection Practices Act and the federal credit regulations seem to demand that. When I was at my prior firm, I did not do that. I did not necessarily think it was required for non-debt collectors. Nevertheless, we do that here as a protection for our clients as well as us. That letter simply says that you have X number of days to pay. There is a breakdown of the amount due, the attorney's fees accrued to that point, and a statement that if they pay by that time, no further fees will accrue. Assuming at that point that the owner does not pay, we proceed to file a claim of lien. Now, this process is the same in North and South Carolina. Claim of lien gets filed. That is filed in the county where the property is located. In South Carolina, it will go to the clerk of court, which is also the register of deeds. In North Carolina, it will go to the clerk of court. That process remains the same. There is a fee for that. The filing fee in North Carolina is $6.25 for the lien, and then 25 cents for each additional page after one. And I do not know what the filing fee is in South Carolina, but it is again minimal. An editorial comment on this, and I proceed to the next slide, but in my opinion, the most important thing for an association to do when someone is delinquent on their assessments is that when that 15-day letter expires, is to authorize getting that lien in place. The lien is very important for various reasons. One very important one is this. If an owner's property is for sale and they are delinquent on their assessments, that lien will show up on a title search. And that the closing attorney at that sale, if the lien has not been satisfied before, is required before he can pass clear title or marketable title or even issue title insurance. That debt must be paid. That lien must be cleared. So it is vitally important for that. It is also important in the event that bankruptcy is subsequently filed. That lien makes the association a secured creditor, which is a much better place to be in bankruptcy court than an unsecured creditor. That means that a secured creditor in bankruptcy court gets priority for payments. An unsecured creditor is at the bottom of the barrel. You may get paid, it'll be pennies on the dollar. I highly encourage all associations to not hesitate to proceed to the lien stage. We can talk about foreclosure and the benefits of that and all that here shortly, but it has been my experience through the years that putting the lien on quickly, efficiently when someone is delinquent is vitally important to protecting the association's rights. Once the lien is filed, normally 30 days after or so, if the debtor has not paid, excuse me, my throat is getting dry. After 30 days and the lien has not been satisfied, we can proceed to foreclosure. That process in North Carolina requires a board authorization. You would receive a document from us, and I'll show you a sample of it here in a minute, that asks you to, pursuant to state statute, to decide whether you wish to foreclose, and that authorization has a specific property address on it that you must approve specifically to authorize foreclosure. I get many questions. Well, what should we proceed or not proceed? What are the factors that we should consider in determining whether to foreclose on a property? Well, one is the amount of the debt. It's secured. In North Carolina, when you put a lien on, it's good for 3 years. So if you put a lien on today, you can foreclose on that lien anytime in the next 3 years. In South Carolina, they never expire. So you could conceivably sit on a lien for a long time. I don't recommend that, but it's possible to take some time and decide. And many of the deliberations that a board considers has to do with the condition of the property. There's 3 pictures at the bottom of the screen. The one all the way on the right is obviously an occupied house. There's a car there. It's well kept. The one in the middle is a little less kept. Looks like it could have been recently abandoned, and the one all the way on the left has fallen down. Now, Of these, my opinion is probably not the one that is the most caring individuals, but is the one that is, from a professional standpoint, the one that I think you should choose first. The one on the right, where it is obviously occupied, people are maintaining it. It is people care about it. They want to keep it. That is the one you absolutely should highly consider foreclosing upon. And the reason for that is the one where you're most likely to get paid. The other two, you may not get paid. The owner may have abandoned those properties. Certainly the one all the way on the left, that thing's about falling down. You may need to foreclose on that one simply because it's in the neighborhood and getting ownership of it means gives you the association the control. You can go in, maybe help maintain it, get the property up to looking better or something. Same way with the middle one. But it has been my experience that a property that is occupied, that is not abandoned, is the one with the highest percentage of chance that you are going to get paid in full without proceeding all the way through and getting title to a property. So that is a major consideration. Um, and here are some statistics. You can just see in a situation where the primary residence is occupied by the owners, there's about an 85% chance you're going to get paid in full prior to the foreclosure either being commenced or being finished. And you can see the percentages drop all the way down. Abandoned property down here at the bottom and vacant land, you're probably not going to your chances of getting paid, your assessments are small. Now, vacant land, if it doesn't have a mortgage on it, the association owns it after a foreclosure, that could be something you could turn around and sell. But abandoned property with a house on it, that's going to be tough for you. And I'm not saying we shouldn't foreclose. Again, there are reasons to foreclose in addition to just collecting debt or forcing or trying to force someone to pay. It could be that the property is in disrepair, it's at the entrance of the community, and you simply need to get control of it so that you can maintain it and own it until something happens, perhaps like a bank foreclosure, which we'll talk in a second. So there are other reasons to potentially foreclose besides simply to collect money. Understand that the more the property is occupied and cared for by the owner, the higher the likelihood is that you're going to get paid in full prior to the end of the foreclosure. This is a sample of the foreclosure authorization form that we use here. As you can see, there's a declaration that payments have not been made. It's been more than 30 days. The address would be inserted. It would be signed by a representative of the association and sent to us. That authorization would get filed in the foreclosure proceeding, whether in North Carolina. South Carolina, it doesn't need to be filed there because they don't require this type of authorization. Nevertheless, it would likely be included. So, going back to our process, the board is decided to authorize the foreclosure. It has filled out the form, and it is either occupied or it is in a position where the association believes the foreclosure is required. What happens? You tell us to file foreclosure. We will immediately do a title search to determine, make sure we have all the necessary owners of the property, and then we will file. In North Carolina, as I indicated, that is commenced by the filing of a notice of hearing. That gets filed with the clerk of court in the county where the property is located. That notice of hearing gets sent to the sheriff for service. In North Carolina, for a notice of hearing type foreclosure, the sheriff will go to the property and attempt to serve the owner. But if he can't, North Carolina law, pursuant to that other statute I cited in there, 45-21.16, allows the sheriff to post it on the door. In South Carolina, that won't work. You have to have personal service via either sheriff's service, certified mail, private process, or if none of that works, publication. And yes, I've had to publish in the newspaper service of process in South Carolina. It takes a while. You have to ask permission to do it, but it can be done. But once the foreclosure is filed, we accomplish service. And after that, in North Carolina, again, it is a abbreviated process. When we file our notice of hearing, we already have a court date. That date is set via the clerk's office. It is either on set dates in the county where the property is located, or we call the clerk and get dates. In South Carolina, it's much different. We don't get to a hearing in court until the following has occurred: filing of the complaint, service of process, and 30 days after service to give the owner time to file a response, or what's called an answer or a responsive pleading. Normally in foreclosures in South Carolina, we do not get a responsive pleading. Normally, we are able to then, after that 30 days passes, we are able to proceed to what's called a default. We file a document with the clerk of court, and we ask for a hearing at that point to have the court enter a judgment. The default means that the defendant did not fail to provide an answer or failed to appear. And at that point, we go to court, and the hearings are very similar at that point, whether we're in a default hearing in South Carolina or at a regular foreclosure hearing in North Carolina. They're very short, usually fairly informal. We present documents to the clerk regarding the amount of the debt, the authority of the association to foreclose, service documents regarding military service, things like that. And then, if the court or the clerk enters the order, at some point down the road, no earlier than 21 days after the entry of an order in North Carolina, and in South Carolina, it's on set dates every month, their property will proceed to sale. If you've ever seen a foreclosure auction, um, I've done them a number of dozens and dozens of them. But if you ever go to a courthouse and you walk to one side of it or outside and you see somebody looking at a piece of paper, reading from it, talking to no one, that's probably a foreclosure sale. 95% of the time, no one shows up at these sales. Sometimes they do. And the reason for that is usually the following reason. There is either a mortgage on the property or some other impediment on the property, perhaps unpaid taxes, and no one wants to buy it at that time. Now, one thing you need to understand, after the sale, at the sale, one of two things can happen. A third party can bid, and if they are the highest bidder, you can actually have a bidding war. Two third parties could bid on the property. They could compete, and that's great because that ensures the association's getting paid everything that it's owed. The other possibility is no one bids and the HOA is the highest bidder. Now, understand the association is not paying any money to bid. The amount of the bid is the amount owed to the association. Every penny. That would include assessments, late fees, interest, attorney's fees, court costs, service fees, publication fees, all of that will be included in that bid. The intent of that, of course, is to make sure that if someone does bid, if the property does sell, that the association is paid every penny. Um, in both North and South Carolina, and I'll stop here. I'll talk about this in a second. There is an upset bid period. The trend nowadays is for people who are interested in property to not bid at the foreclosure sale, but they will bid at the end of the upset bid period. What do I mean by upset bid period? The upset bid period is in North Carolina, 10 days from the date of the sale. So if I did a sale today, someone could come in and bid higher within 10 days. If someone does that, let's say they do it on day 9, the opposite bid 10-day period restarts. I will tell you, I've seen uh, bidding wars for these types of things that go on 6 months. People will bid, and 9 days later, somebody else will bid, and then somebody else will bid after that. If property does not have a mortgage on it, you will likely see a bidding war. And that becomes fun. It delays sometimes what the association when the association gets paid, but it will get paid in full. But it's fun to see these bids go back and forth compared to the value of the property. $200,000-300,000 property going for $40,000 is it can be a windfall for some people. But in any event, many times I get questions on what happens if there is no third party bidder. Well, as I indicated, in North and South Carolina, if no one bids, the association becomes the owner of the property. When the association it becomes the owner of the property, it's got some choices to make. It can rent it. I've had one townhome association who foreclosed on 2 townhomes used one as a clubhouse to meet with for board meetings and such, and did that for over 2 years before the bank came in and took it. Or you can rent it out. That same association rented the other townhouse out for 3 years until the bank came knocking to foreclose. And because there was this long-standing relationship with the renter, we were able to hook the bank up with the renter, and the renter ended up buying that townhome. And so they were a good tenant, and then they became a good owner. Now, I'm not saying that happens often. That doesn't happen often, but it's possible. So the association becoming the owner of a piece of property is not necessarily a horrible thing. No one wants to be a landlord. I understand that. But again, if the association is the high bidder, you're going to own a piece of property. So what do you do with it? You can rent it. You can find a renter. If there's a renter in there, you can continue to rent to that owner, that person. If they don't pay, you have the power to evict them. You have to go through the eviction process. Or if the owner stays, if the owner is still in the property after the foreclosure sale, you have the power to evict the owner through a separate proceeding through the clerk of court or in front of a judge in South Carolina. The uh, the association can sell it and can sell it for whatever it wishes. Um, Again, if there's no mortgage on the property, you can sell it with good title. If there is a mortgage, any sale, the subsequent owner would take it subject to that mortgage. Again, that doesn't normally happen, but it can, depending on the size of the mortgage. So there's a lot of different options. Owning a piece of property for an association is sometimes a necessary consequence of having to do your fiduciary duty to collect. In the end, if there is a mortgage on the property, at some point, the bank will probably come in and attempt to foreclose. Now, another common question I get is, well, if the association becomes the owner of a property with a mortgage, isn't the association required to pay that mortgage? No, it is not. A mortgage or a deed of trust in North Carolina is a contract between the bank and the person they entered the contract with, the owner. That the owner no longer owns it and you now own it as an association does not substitute you into the responsibility to pay that mortgage. What it does mean is that at some point the bank is going to want its money or it's going to have to take the property and sell it just like we did, and they will probably foreclose on top of the association. Now, is that a bad thing? Well, you had to pay the money to get to the foreclosures finished so that you could take control of the property, but for a time you had control. Additionally, when a bank comes in and forecloses, we now have, when they take ownership at a foreclosure sale, whoever buys it, we now have someone who will then pay assessments. So the intent is to get an owner in there who will pay assessments going forward. So um, I think it's a necessary evil, we'll call it that, but it is not something that should be shied away from simply because the association at the end of the may own a piece of property. We can deal with that. And I will also say this, out of every 10 foreclosures nowadays, probably one goes all the way to through the sale and gets a deed. Remember that at any time during the process, from the time the 15-day letter is sent all the way through to the foreclosure order and even the sale and the upset bid, the owner has an opportunity to reinstate the account. You can enter in an agreement for a payment plan. You can do all kinds of things to stop the foreclosure. So keep all that in mind that simply because the process has begun doesn't mean it can't be stopped at any time prior to a deed being recorded. How we doing on time, Ben? About five after? We're doing pretty
Yep,
good.
I think we're good.
Okay. Hmm. I want to give you there's another breakdown here of out of every 20 accounts that get referred, here's kind of how things work. Um, About out of every 20 collection accounts, 10 homeowners pay at our demand letter. Four will pay will pay at a foreclosure or claim of lien warning letter. Two will pay at the foreclosure filing. One will pay at the sale. One will pay after the sale, and then there's one that two or three that we may be uncollectible. It is the process. This process has been labeled um, killing a fly with a cannon, meaning the foreclosure process on an account that's $1,500 or something that someone's behind, or 3,000, 5,000, 200, whatever it is, and compared to the value of the property is pretty heavy. That may be true, but it is also the most effective way to make sure the association gets paid. I will tell you the alternative is to pursue a money judgment through the filing of a lawsuit where you ask the court to give you a money judgment. Well, my opinion on that is this: that is certainly within your right. But at the end of that case, what you have is a judgment from a court that says they owe you money. You still have to go collect it. Now that judgment sticks around for 10 years, but nevertheless, there is there is no money in your pocket. You still have to go through what's called post-judgment collection proceedings, which involves additional hearings and getting a sheriff to seize property and exemptions to that seizure. There's a whole separate collection process to try to collect when you simply get a money judgment. So it is my opinion, and I know it's echoed by those of us who practice in this area, and I believe most management companies agree, the most effective way to make sure you get paid, the association gets its assessments, is through the lien foreclosure process. And I think this graphic bears that out. I want to move on to something that I see a lot of questions about, and this is where where conflict arises. What courts expect when we pursue unpaid assessments? What's the expectation? And I have some blocks here. I'm going to go through each one and highlight these. Proof of a valid debt. Now, everyone's the Declaration of Covenants shows that if you're collecting assessments, there's language in there that indicates that if they're not paid, they are delinquent, and the association has the right to collect. That's the right to collect. But the proof is the ledger. The proof is the amount due, all amounts due, showing an accurate ledger, showing all the late fees, showing the interest, going back to zero, if at all possible, is important to show a clerk or a court on proof of valid debt. If you've got fines on the account, proof that the violation process was followed. What do I mean by that? Meaning documentation that a hearing was held, because in North Carolina, as you hopefully are aware, to levy fines, most of the time, unless your documents say otherwise, you have to have a hearing first before you may levy fines. South Carolina, if you have fines, it is only allowed if your documents say you can fine. So, if you have fines on your account in South Carolina and there's nothing in your documents that allows you to levy a fine, I'm going to tell you that we're not going to collect that because that is not a valid debt. If you have that power in your documents in South Carolina, great. Let's document the process and we'll be happy to proceed to try to collect those. In North Carolina, the statute allows you to fine, but we're going to ask you for the proof that you had the hearing, that you had the notice provided, and showing the fines on the account. Court and the clerk are going to want to know that you complied with the federal and state fair debt laws. What does that mean? Communications with the debtor are correct according to federal law and state law. The court is going to want to make sure if there's a challenge to the action, foreclosure action, that your enforcement action, if it's fines, or your action to proceed to foreclosure is consistent and uniform, meaning that you are using the same standards across the board for everybody in making these decisions. The court is going to want to make sure, if there's a challenge, that the association communicated clearly with the owner, that the communications in writing set forth the amount of the debt clearly, clear guidelines, and clear deadlines to meet. If there is a challenge or a dispute, the court is going to want to know that we complied with bankruptcy law, meaning that if somebody declared bankruptcy, we stayed our action unless we got relief from that stay. And I'll talk about that on the next slide. And all of those All six of those items point to a association acting professionally, running this part of the association like a business, because that's what it is. Where I see problems is when we are, for example, collecting on a debt that's not owed. An example for that would be attempted to collect on fines in South Carolina when fines are not authorized in your documents. If we try to collect that, we not only are not going to get our judgment from a court, but we could be subject to civil penalties of up to $1,000 per instance pursuant to the Fair Debt Collection Practices Act. So the debt must be able to be proven, and we must be able to point to where the authority comes from. We attempt to collect on something without authority, we and you could be in a big world of hurt. Likewise, if there's no proof of fines, or I see this a lot, unreasonable fines. What's an unreasonable fine? I don't know. Well, I know it when I see it, type thing. And I think a judge or a clerk thinks the same thing. What I don't know what your fine schedules are, obviously, because we're not having a give and take at this point. But adopting a fine schedule for certain things and providing proof of that would be very helpful to a court. In North Carolina, as I hope you're aware, but if you're not, the maximum that you can fine is $100 per violation per day. The question becomes, if a violation continues for 30 days and you fine $100, that's $3,000. Is the judge going to look at that and go, wow, that's really high. I don't want to allow that. Not saying that you should or shouldn't do it, but those are types of things that get us into litigation when, if there, especially if there's no proof or of the fines, or if the fines are really exorbitant, say 10, 20, $30,000. I've seen higher. So next is communication with someone other than the debtor about the debtor's account. That is a violation, absolute violation of the federal fair debt laws. There's no one in the association, not the management company, not the board, not a committee, not an officer, should be communicating with anyone other than the debtor about the debt owed by that debtor, period. Any sort of communication to anyone else, and I'm not talking about attorneys, I'm not talking about agents of the association, I'm talking about a neighbor. I'll give you an example. I did have a client recently ask if they could publish the names and addresses of delinquent homeowners to the rest of the association, because the members, there was a lot of delinquent accounts, and they wanted the members to know why they didn't have the money that they thought they should have. As much as persuasion and as much as I like public shaming, that is not going to go very well in front of a court. These types of accounts, delinquent accounts, any account really where assessments are involved, should never be disclosed to anyone outside of the board, your board, the association's agent, or the attorney. It is simply not something that should be disclosed to members in any fashion. Likewise, confusing communications. A scenario has recently come across my desk where we sent a demand letter that said someone owed, I think it was about $2,200 in assessments, late fees, and interest. The owner who owed that money asked to speak at the next board meeting to the board. The board allowed him to speak and came to an agreement on the amount of payment and how much they could pay, and didn't tell us. They collected a certain amount of money. It didn't tell us. We sent our next demand letter, and we got a call from the owner saying that they worked it out with the board. We contacted the board. The board said, "Oh yeah, we worked it out, and they paid us. They're paying us $1,800." And we said, "Well, the debt's $2,200." Well, we didn't know that. Well, the reason you didn't know that is because you didn't ask us. The board should not, no member of the board, no officer, no committee should be having any communications with a debtor after the matter is sent to collection, period. It creates confusing communications with regards to the amount owed. In addition, a decision made by a board to collect less means you're bound by that decision. If that is conveyed to the owner, Whatever amount that you convey, you are bound to that. So if it's not the full amount owed, you're not going to be able to get the full amount owed. Okay. Any representation of an amount owed, it must be is what is going a court is going to hold you to. Additionally, if there's documents sent out, and I've seen this too, we send a demand letter with an amount, but then an updated statement gets sent something different. That can be confusing to an owner. All communications, once the matter is sent to collections, need to stay through the attorney's office if at all possible. Preferential and arbitrary treatment. There is an analysis the association board of directors must go through when determining whether to place a lien and then foreclose. And now that analysis is whether there is a debt, are they delinquent? What is the chance we're going to get paid? All of those things go into it. Those factors should not vary from owner to owner. They should remain the same. Where the association board has some leeway, I think, it has to do with whether the owner, for example, requests a payment plan. They come and they provide some information that they have a hardship and they ask for a payment plan. That is something that, if documented, is fine. If you grant it to one owner and not another, but document it. If we have to go in and defend why you granted a payment plan to one owner and not the other, if I have the documentation as to why, the court is likely not going to set that anything aside. It's not going to come down hard against the association because you documented. You are people. You're allowed to use your discretion. But if it's not documented, or if it's simply arbitrary, if it's not documented, it seems arbitrary, period. That's what I'm going to say. Without proof of why you did it, it's going to seem like you just did it because you like the person, or you didn't like somebody else and you didn't do it for them. That's never going to fly with the court. And don't take this stuff personally. Excuse me. There are many times sitting as when I was sitting as a director on my board that I felt personally attacked and responsible. It unfortunately is part of the job. However, when we are dealing with collections, this is a business decision. You are running a business that is a nonprofit corporation formed under the laws of North or South Carolina. In that light, the decision you make also must be based upon your fiduciary duty. It is my opinion that the board of directors must take whatever steps necessary, if at all possible, subject to very few exceptions, to collect every assessment that is owed to the association. That my belief, my opinion is that that fiduciary duty comes with you sitting in the director chair. Let's talk about some potential changes in the law in the last few minutes before we take questions. Potential law changes. South Carolina, the Wild Wild West, as I like to call it, a few years ago adopted the South Carolina Homeowners Association Act. It had nothing to do with assessments. It has to do with enforcement of certain things, recording of certain rules and bylaws. But there's been nothing in the last few years that have been passed in South Carolina to address collections, and there never has been. And the session this year for South Carolina is closed. I sit on the South Carolina CAI Legislative Action Committee. I've said this is my second year on it, and I'm always surprised at how quickly their session ends. And there's just been nothing proposed regarding assessments in South Carolina and collections. So you guys can rest easy. There's nothing coming this year, and frankly, there's probably not going to be anything coming in the near future. North Carolina, on the other hand, you all may recall a couple of years ago, House Bill 542, which which was intended to revamp much of the foreclosure process, the including a minimum amount to place a lien and then foreclose, et cetera. The that bill died in committee, fortunately. However, a version of it has been revived this year in Senate Bill 378. There are some major changes in that bill. It passed the Senate. Went to the House, and the House combined it with another bill of theirs, House Bill 372, that had nothing to do with homeowners associations. So now, though, both those bills are now in various committees. Where they come out after that, I don't know. We are waiting to see. But some of the proposed changes include the following. In a situation where an owner is going to collection, right now we have to mail the 15-day letter, we have to mail the notice. In addition, this bill would propose that if we have an email and the owner has agreed to accept email communication, um, that we also have to attempt to inform the owner of the collection afterwards via email. That may not be that big of a deal. Um, if they've, if an owner has submitted their email and saying, hey, board of directors, homeowner association, this is how I want communication to come to me. Okay, we already have it. It seems like it's not that big a deal. Where it starts to get a little more dicey is when in dealing with fines. The bill would require if you are delinquent on assessments, a lien for that, and then if you are delinquent in the payment of fines, a separate lien for fines, and that lien must be placed within 90 days of the levy of the fine. Um, that is a big change. Right now, the liens can be placed for any debt, whether it's fines or assessments or both. In this case, it would simply require you to keep two ledgers, a ledger for assessments and a ledger for fines. Um, in addition, and this is the one that is really, really bothersome, attorney's fees, as you recall, in North Carolina are recoverable in full. A change in the law would then make them not necessarily recoverable in full. The language would be proposed would change it to reasonable attorney's fees may be awarded. In essence, it shifts the financial responsibility to pursue collection from the owner who is delinquent to the association. And what I mean by that is this. In Let's say an owner has a $500 debt and you incur $500 in attorney's fees to collect it. The law today, that owner would be responsible for that $500 attorney's fees, no question. If the new law passes, a court could say, no, I'm not going to award the attorney's fees. So the association paid $500 to get $500 and basically recovered nothing. Additionally, there is case law that in North Carolina and throughout the country that when collecting a debt, a reasonable attorney fee is 15% of the debt owed. Take back to my $500 example. If you were collecting $500, 15% of $500 is, well, 10% is 50, 5% is another 20, so $75. So on a $500 debt, you may have incurred $500 in attorney's fees. The judge would award you 75 in attorney's fees back. And so you would lose money. You wouldn't lose money, but you would not collect hardly anything on that debt. I think the bill is, and those of us who practice in this bill is bad. The repercussions of this really, I think it destroys an association's ability to efficiently collect delinquent assessments, and I think it will deter most collection activity because if you're not guaranteed to recover your attorney's fees, you're certainly not going to hire an attorney to do this, and I totally understand that. And as a result, many delinquent assessments will not be collected. I'll keep you updated. My firm sends out blogs with updates. One came out earlier this week. These bills are in committees right now. What has to happen in the legislative process is that both committees have to come out and there has to be an agreement as to the language before each can vote on it. That's where the other bills died the other year. Hopefully this bill will die again, or in the alternative, they will come up with something that will not take away the power of the associations or the financial ability of the associations to collect the assessments that, in my opinion, that they are required to do because the documents require those to be collected. That's my presentation. We are 5 minutes ahead of time, Ben, which is amazing considering how much I like to talk.
Well, thank you very much, Chris. We do have some questions. So the
Sure.
first is kind of for CAMS, and maybe let you comment on it too, because I think once collections leave the management company and roll over to the attorney, your process may differ, but
Sure.
the question has to do with how payments are posted. And I think it was in one of your earlier slide talking about fines and assessments and/or fines are treated like assessments and vice versa. But
Right.
we do have a posting order, and that does start with fines. Then it rolls into late fees, interest, and assessments. And so there is a posting order how that occurs. Once it gets into your office, and once you uh, talk about that.
Well, we have the same process. The only difference there is if we filed uh, proceedings such as a lien or foreclosure and we've incurred attorney's fees, the process would be any payments would be first applied to attorney's fees then and costs, and then back through in the order that you indicated. However, um, I will say this: if someone enters into a payment plan, we are simply collecting that money and sending it along as necessary, not necessarily apportioning it like CAMS would. We collect the money and we send along. You guys apportion it, however. The one thing I will say about payment plans, I hate them. I absolutely hate them. They can be an administrative nightmare, but I also recognize that they are not only are a necessary evil, they can be essential in continuing the cash flow of the association. It is my opinion that if the association decides to enter into a payment plan, it needs to be a substantial amount down upfront, and then a short period, months, paying it off. Um, if they default, my position is you get a half down, at least you got half. And before you have to proceed through the rest of the process. I know that's an aside from what the question was, but I thought I should point that out. I think they are a necessary evil. I will note that there is no law in either state that requires homeowners associations to enter into payment plans. However, that means they're completely discretionary and they are probably useful.
So next question is Fair Debt Collection Act. I know you touched on this later in the presentation, but does the Fair Debt Collection Practices Act have a role in North Carolina HOA collection? So the answer would be yes.
Yes, yes, it does. It, federally, attorneys are, at least in my opinion, it's questionable whether we are debt collectors because we are not in the primary business of debt collection. And really, that is really the gauge is are you in the business? Is the person who's doing the collecting, are they primarily in the business of collecting debts? Your management company, CAMS, is not in the primary business of collecting debts. It's just one of the things you do. I would say you're not a debt collector. Nevertheless, um, the standards with regards to the federal fair debt laws and even the state fair debt laws are pretty strict. And we never want to run afoul of them, even if it's questionable whether there's debt collectors involved. The penalties are steep. A violation of it is $1,000 fine per penalty per event. There are class action suits going on. There was one in South Carolina, and I know there's a couple going on throughout the country against uh, management companies and attorneys for violating certain language that is required to be in the notices. So if you've ever seen the notices that come out of our office, my former office, and this one, there is the mini Miranda at the bottom. That's what we call the mini Miranda. Anything, this is a communication from a debt collector. Anything, information gleaned will be used for that purpose. You will see some USC, 15 USC language in there. That is all to protect the client, the management company, and the attorney.
Okay, I don't know if you touched on interest, but is interest accessible at any particular time during the collection process? And if so, what is the rate? And I know North Carolina has statute and South Carolina does not. So,
That's correct. You've hit that exactly. So the interest is allowed in North Carolina. Well, let me go to South Carolina. It's allowed to be collected in South Carolina if the documents say you can collect interest. In North Carolina, there is a difference of opinion on whether the statute allows it. And what I'm specific statute I'm discussing is 47F 3-102 and the 47F and 47C 3-116. My opinion is if it is in your documents, you may collect the interest at the rate that it is stated. However, no higher than 18% per annum. And that is simply because after that, you're getting into a concept called usury, which is a complicated legal concept that I don't even want to go try to explain because it'd take too long. But um, when do you start assessing? When do you start collecting interest? In my opinion, you start collecting the moment that they become delinquent. It starts accruing. Now, there's also been a question, can you charge interest on interest and interest on late fees? No. Your interest is on the delinquent assessment. You should not be charging interest on late fees that accrue or on interest that accrues on the non-payment of the assessment. And the reason for that is usually the wording that is in the declaration. The interest is assigned to the assessment. Late fees and interest are not really assessments. And that is a very conservative approach. Again, when we are dealing with collection laws, it is better, in my opinion, to be more conservative, so that we can collect every penny that's owed.
Okay, so it is just after 5:30, so I wanted to say if you need to drop off, feel free to do so. I will continue to ask a couple of questions and we'll get through all of these. So if a foreclosed home is financed, won't the bank have to pay the assessments to protect their investment?
Interesting question, and I like where you're going with it. So the answer to that is this: if a bank forecloses, there is a section of 47F and 47C 3116 that provides that after the close of the upset bid period, and if you remember, that's 10 days, or if somebody bids, down the line, when the upset bid closes, the rights of the parties to the foreclosure become fixed. Here's what that means. One, after the upset bid closes, the owner is probably done. They really can't reinstate at that point. Two, whoever was the highest bidder becomes responsible for the assessments. In a situation where a bank forecloses, once the upset bid period for that bank foreclosure occurs, the bank, at least as far as the North Carolina Homeowner Association collection statutes are concerned, is the owner, and we can start assessing on day 11. Now, we have to be monitoring that because there's no deed on record. The deed may not go on record for months. And that came about because what was happening, this is about 10, 11 years ago, banks were going through the foreclosure process, which is very similar to the HOA process in North Carolina, and the same in South Carolina. And they were getting their foreclosure order, but they were not proceeding to sale. Or they would proceed to sale and they wouldn't record a deed. And their concept was, well, if we don't record a deed, then they're not going to assess us, the homeowner association assessments. Statutorily, the General Assembly got together and said, no, that's not right. And in a win for homeowners associations in North Carolina, the that statute that was changed to talk about the rights of the parties becoming fixed. So yes, banks would be required if they're the high bidder at a foreclosure sale, after 10 days, they got to start paying assessments.
And we like that.
We love that. And you know why? Because it's a corporate entity, they're going to pay.
Yeah.
And they're never going to allow us to foreclose on them, so you're going to get paid at some point.
Unfortunately, generally the bank follows up with that foreclosure right after and moves somebody in. And so, yeah.
Right.
But
Exactly.
can assessments still be assessed through the lien and foreclosure process? And how are those new assessments collected?
I have to think about the wording of that question. The answer to that is yes. Assessments continue to accrue, and this is a fine point of the lien part of this. The lien, when the lien is placed, it secures all sums due at that point and all sums coming due until the matter is foreclosed. So assessments continue to accrue, late fees continue to accrue, interest can continue to accrue. And how do you collect that? Well, you hope, again, 17 out of 20 times before you go get finished with a foreclosure, an owner's going to pay. Well, when they pay, they're going to have to pay not just the amount on the lien, but all sums due, all sums that had come due, all attorney's fees, interest, court costs, all of that.
Yep.
Or they
Yeah.
would not be allowed to reinstate otherwise.
I think the language is generally any future assessment owed or future due money owed, or yeah. So
Also,
yes.
and the statute even says the lien secures all sums due and coming due.
Okay. We have $58,000 in collections and seem to not be getting anywhere with them. Any feedback on what to do on and what are likely the issues in getting them collected? Are they formalities within the notification process or letter? It's frustrating to have about 1/3 of our operating budget sitting in collections.
Wow. Um, I don't want to ask who the firm is because if it's us, I got to check that out. And I'm not being flippant. That is a concern. The answer to that is I don't know without more specifics. I can speculate as to many things. For example, I see accounts sitting a lot when management companies are changing. Documents aren't transferred. Accounts can't be traced back to zero. I sometimes see if there is in some communities, it depends on the type of community, but some communities, there are so many that are in collection, the association cannot afford to proceed on all of them at one time. Now, that depends on who your firm is. We front the costs here, so it wouldn't cost you anything to begin. So I would really need more information. Um, it could be paperwork. It could be, I don't know. I'm sorry. That's a tough one
Yeah,
without
I'll
more
I'll,
information.
I'll say it, a lot of the times, and so many different situations to talk about. But Chris, you talked about this earlier with the business judgment rule, and one of your co-attorneys talks about you need to be practicing the business judgment rule, not the good neighbor rule.
Mhm.
And you're not State Farm, so
Yeah, I
fire
mean,
boards sometimes do not enforce collections the way they technically should. So, get aggressive and focus on the biggest first and kind of start chipping away at it to get it coming in.
yeah, and I think that's really the question is have collection activities commenced? Because if they haven't, that is a decision. That's a board issue. That is an internal issue that we don't want to collect on our neighbors. Well, if you're sitting in those chairs, you have fiduciary duty to, and it's not personal. It is absolutely a business decision that must occur.
Okay. What happens if you have a foreclosure sale at the date and then after the foreclosure, within the 10 days, the owner files for bankruptcy?
Well, remember that statement a few minutes ago about the rights of the parties becoming fixed. The rights of the parties have not yet become fixed if they file bankruptcy within the upset bid period. I actually had a foreclosure where I went all the way through in South Carolina, got the order, and before the sale. And in South Carolina, the sales occur, I believe, on the second Monday of every month. And the judge conducts the sale. In North Carolina, we have bidders that do that. Um, we had to stop. We had to wait. We got notice of the bankruptcy. The judge stayed the sale, and we waited. And fortunately for the association, in that case, the bankruptcy was dismissed within 2 months because of the owner's failure to follow the plan, and we ended up selling the property. But that can occur. When an owner files bankruptcy, we have to, unless the foreclosure is done, meaning the rights of the parties are fixed, upset bid period is done, we have to stop. Now, we can get relief from that. We have to ask for permission from the bankruptcy court to get what's called relief from stay. The stay is what happens when a bankruptcy is filed. All collection proceedings are stayed or stopped in the position they are in until one of two things happen. The bankruptcy is discharged, meaning the debt's gone, or the bankruptcy is dismissed for failure of the debtor to do something according to the bankruptcy plan. In situations where bankruptcy is filed, we routinely reach out to the bankruptcy attorney to see if we can get some sort of payment plan outside of the bankruptcy to try to get the association paid. Many times that is successful. Otherwise, we ask for relief from stay for various reasons. Many times we obtain that. Once we obtain relief, then we can proceed.
Okay. And we do have a full webinar on bankruptcy. I think it was November, December last year. So I think it was with another attorney in your firm, Chris, Michael Teledero. Teller.
Tellercio. He actually is no longer with this firm.
Oh, okay.
He's with his own firm, actually.
Well,
But Michael knows bankruptcy. I'd go to him before anybody else. So yeah.
yeah. So next question. We're an HOA in South Carolina and have owners who have received fines but not paid. We're interested in collecting or in connecting with a collection attorney. I assume there are initial consultations where we can present to the attorney with history facts to assess the validity and legitimacy of the case. Can you tell me how that works? Is there an initial consultation for a fee or a free meeting that would be arranged?
Well, I don't want to solicit business, so I'll just say this. If you wanted to talk to, for example, you want to talk to me about that, I wouldn't charge because I mean it's collection work. I could give you a rundown of the process and tell you what the fee schedule is. Understand, I think I said this early on when our process is different from where I used to be. Here, you don't pay any attorney's fees or court costs until the end. Either they pay or the end of the foreclosure or process or whatever. So, if that is something that you're interested in, my information is on the slide, so I can certainly get it to you. If you want someone close, I don't know where you are in South Carolina. If you want someone closer, the initial consult information is varies by firm. Some charge an initial consult fee, some do not.
And I'd say just get with your association manager and they can get you in touch with Chris or
Yeah,
anyone else.
or anyone else.
So, at what point is the foreclosure public knowledge?
Well, the filing of the lien it begins the process, and that is a document filed on public record. So technically speaking, the moment the collection process formally begins, it's public knowledge. That is what's called constructive notice to everybody in the world that a lien's been filed. What generally happens is when the court proceedings are filed, either the notice of hearing or the complaint in South Carolina, again, that's all public record as well. The foreclosure orders, all of that are in court files, public record, accessible to anybody. So they're public the moment the lien's filed. I will note both in North Carolina, at the end of the foreclosure, uh, the owner of the property will get what's called a trustee's deed. We are the trustee for the property in the foreclosure. When that is filed, after that, we file what's called a notice of foreclosure. That is a notice that is filed on top of that, the deed letting everyone know that a foreclosure has occurred. South Carolina, you're not required to do that. Um, that said, again, it's public from the moment we file a lien.
Okay, what is the best practice on documenting board decisions regarding debts that allow decisions to be recorded but not shared with a broader HOA membership?
Well, all decisions regarding assessments, collection of assessments, delinquent assessments, I would say violations and fines need to be done in what's called an executive session. Your board meetings, in my opinion, should be divvied up in two parts. A general meeting, which could be open to your members if you choose to, where minutes are taken. You're talking about the landscape contract and approving that or whatever. When you're talking about sensitive matters such as collections or violations, legal matters, you would go into closed session, and at that you could keep what's called executive session minutes. Those would not be disclosed to the membership in any fashion. The only time any or at least notes or some sort of resolutions coming out of those that would reflect action taken. However, when you go back into general session after the executive session, you would simply indicate that the executive session is closed. So you would have some sort of notes or executive session minutes. In my opinion, an example of bypassing the need to create minutes is that if you recall one of the earlier slides, we had the foreclosure authorization. That document is an association record when you fill it out and sign it. A copy of that would reflect action taken at an executive session about that property. You authorize foreclosure. So it's those types of things. You could draft resolutions. There's all kinds of ways to document it without putting it out into the public. My opinion is shared, I believe, by almost all association attorneys and probably managers that executive session minutes, notes should never be disclosed to the membership absent a court order.
Okay. I hope I'm going to ask this question correctly, but can a violation be applied to a home for collections, liens, or foreclosure? Also, what about it is in probate? Some board members say there are laws which prevent us from applying a violation to a property. So maybe two different issues, but I think the
Yeah. Um,
I think if it's a
so
violation, can it be applied on a property? So that would probably be
got
the
you, got you, got you. So the answer to that is whether a home is in probate or not, it doesn't matter. That's a whole separate issue. Where I think you met a where you get into problems if there is an owner who is deceased and something is being probated or something. Notice to the owner of collections, notice to the owner of violation becomes difficult. Okay. We have to find out, for example, if a home is owner is delinquent and there's someone is deceased. In the foreclosure process, we have to find who the heirs are if there's nobody determined to be the heirs and through probate. So that can be a step, that could be a time-consuming thing. We have to, in North Carolina, ask for a guardian ad litem to be appointed. A clerk would have to appoint someone. That person would have to investigate who the heirs are. That doesn't stop the collection process. We are allowed to collect and for assessments, both in North and South Carolina, the language in almost every document I've read down there that's written correctly uh, provides that the payment of assessments is incumbent upon ownership of the homes. In other words, you own, you must pay. If you don't pay, the lien is automatic. The requirement that to pay does not stop simply because a home is in probate. Likewise, uh, violations are kind of the same thing. If a property's in violation, a property's in violation. The issue is in proceeding to a violation hearing to potentially levy fines, we have to make sure we notify the correct people. That could be the sticking point. If we don't know who the heirs are, who are we notifying? That would require an investigation. I'm not sure if I'm answering that question. Kind of I think the question really involves, can we proceed? Yes. The hindrances to proceeding would be notice, finding out who the people are and notifying.
Okay, last two questions. How
Okay.
does the board determine a fine that is not considered a daily fine of $100, but a fine based on the total infraction?
I actually am reading that one. How does a board determine a fine is not considered a daily fine 100, but fine based on total infraction? Okay. So if I understand, the fine is levied based upon what was done, not a daily accrual. Okay. So I want to make sure we understand if we're talking about North Carolina, you, the answer is the procedure is this. The Now, I lost my train of thought. Let me go back
Hmm.
here. It's again, I'm sorry.
Oh, I did close it. So how does the fine? It's not a daily fine,
All
but
right.
it's
All right. I'm gonna use an example. You left your trash can out, so you levied a $50 fine for the trash can. Period. You're done. You're not going to levy it again. That's a distinction versus if they leave it out 5 times, you've only levied one fine, and you don't want to levy another one. Okay, you have certainly that is your choice. There's a couple of ways that I've seen that I've recommended people that boards deal with fines. One is to have a graduated fine schedule, meaning if it's an ongoing type violation, the first week it's $25 a day. This for 2 weeks, and then after that it's $50 a day for 2 weeks, and after that it's $100 a day, etc. That is one way to go about dealing with it. Where I see issues is if you just pick the violation. So again, let's use the trash can violation. You find them $50 because they didn't pull the trash can in time, but they continue to do it. Well, if you've chosen only to fine them the one time and it's not a continuing violation, the most that you have fined is $50 and they don't pay it, then what do? I will tell you, I'm not going to put a lien on for $50. That's not the filing fee for foreclosure in North Carolina is 300. I'm not putting a lien on for less than 300. So again, I'm not sure I'm really addressing the question. My opinion is if you're going to levy a fine, the purpose of levying a fine is to get compliance. If it is a situation where I guess I can foresee this, somebody put a fence up in the wrong spot. You don't want to make them remove it, but you want to document the violation and you want to put some kind of penalty. Okay, I can see that. I can see $100, you're done, your fence is in the wrong spot, but you don't have to move it. I'm not sure what that really does, but I guess I can foresee something like that. Again, if they don't pay the fine, I would not put a lien on for $100 to collect that. Um, So you really, at that point, I think the owner could probably say, well, there's really no penalty. Maybe when they go to sell, someone would ask if they're delinquent on something and would probably get a notice that they are. Maybe you get the 100 then. But again, I do want to take 1 minute to talk about the distinction here. Assessments are required to be collected. Everyone's required to pay them, period. Violations and fines, the fine process is there for this purpose, in my opinion. That is to gain compliance. It is not for the association to make money. It is not for the association to go make it, make an example of somebody. It is there as an attempt to tell the owner, this is going to hurt you if you don't comply. And so when you are putting a fine schedule together, the concept of an ongoing daily fine, even on a graduated scale, can be a very effective deterrent to the behavior you're trying to correct. Okay. I want you to keep that in mind. A one-time fine where the violation's not cured, I'm not sure does anything.
okay. And last question.
Mhm.
When a lien is filed, does it go against the title? Whereas if the owner attempts to sell the property, this will shield it on the title search.
I think the question is if a lien goes on title. All right. So when a lien is filed in either North or South Carolina, it gets a file number in the clerk's office. Okay. A person who is attempting to sell their property, a potential buyer will do a title search. A lien will show up on a title search, and that lien will alert the potential buyer, hey, I am not going to get clean title to this property because of this debt. That's what a lien does. A lien is putting everyone on notice of a debt. That debt must be paid. And if it's not paid, here's what happens. If I go to buy your property and it has a lien on it and I say, I don't care, I'm going to buy it anyway, and I buy it, you as the homeowners association can foreclose on me, even though I didn't incur the debt because I bought knowing the lien was there and I chose to buy it anyway, and I chose not to satisfy it. So the association could foreclose on the new owner if it's not satisfied. So um, liens show up on title searches. It will impede sales. Um, it 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 is a cloud on title to the point where A buyer cannot obtain marketable title without that lien being cleared.
Okay. Well,
All right.
thank you all. Thank you for
Thanks, folks.
staying with us through the end of this. I told Chris when we were getting started, he's going to have to talk quick, and we still
I
went
get,
30, almost 30 minutes over.
whoa, 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 no, 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 no. I finished at five ahead. Come on now.
Okay. But
Thank you.
again, thank you all for joining tonight. The session is recorded. We will be posting it on the camsmgt.com website. So under board member resources. So we look forward to seeing you next month, the third Thursday every month. So thank you again. Good night. Thanks, Chris.
Thanks, folks.